Good afternoon. Welcome back to the PENC virtual Raleigh seminar. We appreciate you being with us today. We're at our last session for today, the FIU bridge collapse. We are going to be taking questions at the end of the presentation today, so please feel free to type those into the questions box or the chat box, and I will read those out loud at the end of the presentation. As always, if you have any technical difficulties, please send me an email or use the chat box and I will try to assist you. Today's presenter is Aaron Mann. Aaron is a principal with Terracon and its senior attorney for litigation matters, who has been practicing law for nearly 2 decades. At Terracon, he oversees claims, litigation, intellectual property matters, and internal investigations. He manages outside counsel acting on behalf of the company and works internally to troubleshoot project issues and avoid disputes before they escalate. Prior to joining Terracon in early 2016, Aaron was partner at Hush Blackwell, an Am Law 100 law firm, where his practice focused on litigation. During his time there, Aaron spent 4 years working in the firm's office in London, England. At the beginning of his career, Aaron served as a judicial clerk for a U.S. district judge in Kansas City, Missouri. Aaron earned his JD from the Creighton University School of Law in 2001. Aaron, thanks so much for being with us today.
Thank you. Appreciate the opportunity, and thank you all for joining me here today as I come to you live from my basement here in Kansas City. And I point that out not only because it's an opportunity to talk about our football team and the fact that we're still trying to come to grips with what it's like to have a successful one, but also because Kansas City actually was the location of a pretty significant construction and engineering disaster nearly 40 years ago today, and you may be familiar with what I'm talking about, which is of course the Hilton Skywalk collapse. That was in 1981, and the reason I bring this up is because that is still part of the shared experience of the community here. And I know it's something that still is often taught as a case study to new engineers. Again, it's been almost 40 years, but it's something that we're still talking about, we're still dealing with. And I think that today, when we talk about the FIU bridge collapse, I think, fortunately, not to the same extent in terms of the number of fatalities, but I still think this is something that is going to be part of certainly the shared experience of the community, but I think of the engineering community, the broader engineering community as a whole. And so I appreciate the opportunity to be here today to talk about it. I feel like I need to give a disclaimer up front, which is, obviously you heard my bio, and what you did not hear was that I have any background in engineering whatsoever. I spend my time arguing about whether or not engineers did a good job, but I struggle to put together IKEA furniture. So I would ask that as we go through some of these things today, that you understand that I'm coming about this from a kind of a legal risk management perspective, and not from the perspective of truly engineering. So let's talk about the project. This was a $12 million pedestrian bridge that the Florida International University had commissioned, and the idea was they wanted to link up their campus on one side and cross over this busy road and a canal to a residential neighborhood that was on the other side, a neighborhood where a lot of their students lived, and they wanted to provide a manner for their students to get to and from the campus safely. And oddly enough, the impetus for this project was that one of their students, a couple years before this project had come into fruition, one of their students was crossing a busy road trying to get to campus and was struck and killed by a car. And so from the very beginning, the idea behind this was to provide safe transit for their students. But it was also supposed to be, I think, kind of a signature piece for the university. And if you look at this design, this is an impressive looking design for a pedestrian bridge. To have the very tall pylon, to have these cables stretching down, this was to be a focal point as well that I think the university was really proud of. The project itself was funded with FDOT money, but FIU was the they were kind of the contract administrator for the project. But FIU and FDOT worked in pretty close conjunction with one another on this, and so they put this out to be a design build project. And in terms of the project team, again, you have FIU and FDOT acting as sort of co-owners, if you will. You have Manila Construction Management, or NCM. So they were the design builder. They were also the general contractor for the project. You have FIG. FIG was the prime engineer, the prime designer and the structural engineer of record for the bridge. You have Louis Berger. Louis Berger was hired to do the peer review on the design. And then you have Bolton Perez and Associates. They were the CEI firm, and they were hired directly by FIU and FDOT. And I'll explain to you in a little bit why I point that out, why that's important. But it's important to keep in mind that, again, the CEI firm in this case is working on behalf of the owner. So as far as the design itself goes, again, very imposing, impressive structure. But really what it comes down to is you have these two spans. You have the main span that goes over 8th Street, and you have the back span that goes over the canal. All of the steel pipes up above, everything that ties into the pylon, those are not structural components. Those are just for aesthetic purposes. So this is not a suspension bridge, this is a truss bridge. And there is that single truss running down through the middle of the main span and the back span. And it's a single concrete truss that's reinforced with post-tension cables. The design itself, as we go into this, eventually there's going to be a report that's issued by the National Transportation Safety Board, and they go to great lengths to describe the unique nature of this design, of this bridge design with a single concrete truss running down the middle. They refer to it as unique. I think they refer to it as unusual. They say they've never seen a bridge that was designed like this anywhere in the world, which is an interesting thing to hear, and you'll see why, as they were also very critical of that design. But as you can see here, we're talking about two spans primarily that rest on these the piers on the end and the pylon in the center. And as far as construction goes, the construction was to take part in 8 stages. And today what we're going to talk about is stage 3, which is the erection of the main span. Unfortunately, that is only as far as the construction progressed. But stage 3 meant that you were going to have the main span resting atop the south pier and the pylon. And so the way this bridge was constructed, they used a technique called accelerated bridge construction, or the ABC method. This was something that actually was it was a technique that was devised by FIU. So not only was this bridge itself a point of pride for the university, but even the manner in which it was being constructed, it was kind of their technology at work. And the theory behind ABC and the idea behind it is you have these components to the bridge that are all they're cast off-site and then brought into place. And so you essentially hook up, again, lawyer, not an engineer, you hook up these large pieces into the final design. And one of the reasons for that, and one of the key advantages of that, is that you don't have to shut down traffic for as long. And so today, or excuse me, not today, but in this picture, on the day of this picture was taken, you can see they've shut down traffic for the day as they're bringing the main span into place. And they did this on March 10th. So March 10th, 2018, they're moving the main span into place. And this was a big day for the project. It was a day of pride. You had 6 PEs from FIG who were there, including the president of the company, to watch this main span get put in place. The first real tangible piece of this bridge really coming into focus. And so they brought it into place. They set it down on the pier and the pylon as designed. And then after checking it, they removed the bracing from underneath. They removed the machinery, and it spanned the road, Southwest 8th Street. Again, what it was designed to do. MCM, BPA, FIG, they all examined it. They saw no issues at that point in time. So later that day, again, per the design, certain members, specifically number 2 on the far left of this diagram and number 11, which is highlighted, the PT tendons in those members were de-stressed by VSL, who was the post-tensioning contractor. And as they de-stressed number 11, immediately after, some cracks began to appear. And on the right, you can see this is a screenshot from the VSL technician's cell phone. He took these pictures and sent them to MCM and said it cracked like hell. Now we can have a whole discussion about how to properly use exhibits at trial, and and are you creating things that are good or damaging to your company? This is going to continue to be the picture that defines everything about this project. That on day 1, you've got the contractor taking pictures and telling MCM it cracked like hell. And this is what they sent. So on March 12th, MCM starts taking more pictures. Bolton Perez is out there as well. They're taking pictures of these cracks. They're noticing these cracks here and pretty significant cracking here and all the way down through here. And all this is in the same area. This is all in this area where number 11, which comes down here diagonally, comes into number 12 and the deck. So they take these pictures and they send them to FIG, and they ask for their input. They ask for them to review it as quickly as possible. Well, unfortunately, that email sat unopened until the next morning. The next morning, the engineer at FIG opens the email at 8:30. They're looking over these pictures. An hour and 15 minutes later, they respond. And they tell them to put in some plastic shims, but they say that no jacking is required. And they say, we do not see this as a safety issue. So you have the structural engineer of record saying, we do not see this as a safety issue. They've looked over the pictures. They're not concerned. Same day, later on that day, the engineer from FIG leaves a message for FDOT to inform them about the cracking. But they say, we do not see this as a safety issue. We don't see that there's any safety issue there. So we're not concerned about it from that perspective. Unfortunately, that voicemail was not opened until after the bridge had already collapsed. And so FDOT would say that they were never properly aware of the situation. At least that individual was not. FDOT as an organization was. And then later on that day, 5/18, FIG emails MCM. And they say, we've evaluated this further and we've confirmed this is not a safety issue. So again, structural engineer 3 times now, not a safety issue. At the same time, FIG recommends that they re-stress the post-tension rods in member 11. And this is something that is going to be examined pretty closely later on, because this is not part of a design. FIG would say they're basically taking a step back. The original design was when the bridge was put in place, those tendons were stressed. Then they were de-stressed. Well, now they're re-stressing them, so they're putting it back in the condition it was before. NTSB and OSHA both say that was a design change that was not properly vetted. Nevertheless, that's the decision that was made, and that was communicated to the team. And as it turns out, VSL, the post-tensioning contractor, they could not get out there for another 2 days, so they're scheduled to come out on the 15th to do this work. Meanwhile, the cracks continue to grow. So this is March 14th. You can see this is 4 inches deep, and a pretty significant length for that crack there. We've got more pictures here from the connection between the deck and diagonal number 11. And this has been in place for basically 3 days at this point, and seeing cracking like this. We've got longitudinal cracking at diagonal 11. In this case, well over 1 foot long. and even more here on either side. So all this is on March 14th. MCM sees that these cracks are growing, but they don't specifically tell FIG that on the 14th. Instead, they call FIG and they say, we're going to set up a meeting for tomorrow, for the 15th. And we want you, FIG, as a structural engineer, we want you to tell us what's going on. Give us your findings on these cracks. And so FIG spends that day analyzing and working on their presentation for the meeting. Meanwhile, VSL is told that they need to mobilize for retensioning also on the 15th. And I'll point out, while all these discussions are going on, while everyone is taking pictures of these cracks, while they're discussing what they think may be the issue, traffic continues to flow on Southwest 8th Street underneath the bridge. So on March 15th, 7:45 a.m., people start arriving to the site for this meeting. You've got two structural engineers from FIG, including the engineer of record. You've got MCM, you've got Bolton Perez. They all go out and examine these cracks. And at 9 o'clock, there's a kind of an all hands meeting in the trailer. So you have MCM, you've got FIG, you've got the university, you've got FDOT, and Bolton Perez. And at that point in time, FIG gave a presentation to everyone. They said that they have no safety concerns. They said that this was only a temporary loading condition. At the same time, FIG could not explain why the cracks were as extensive and what it was they were seeing. They said it was not replicated by the engineering analysis. And so while this is going on, two things are happening. Number one, VSL goes out to begin their post-tensioning work with 3 employees on the bridge. And again, traffic continues to flow under Southwest 8th Street. Which takes us to 1:46 p.m. on March 15th. Now, I feel like I need to make this clear. I don't show that video to be gratuitous. I don't show it to sensationalize this. I truly hate watching that video, and I've watched it many times, and every single time, it's uncomfortable to watch. I show it because that's what happened. That is the true consequence of some of these decisions that were made. And so even the design that I have here on this next slide, that talks about the mechanism by which the bridge failed. If you look at that, what's missing? There are no members of the public underneath that bridge, and unfortunately there were that day. And so what happened was, as VSL was doing their work, as they were retensioning 10 and 11, they experienced a blowout of concrete, and the span, because again, because it's supported with a single truss, and there will be some that say that it lacked redundancy, that the bridge lacked redundancy, but because member 11 failed, the entire bridge failed, and the span fell 18 feet to the ground. And in that moment, 6 people were killed. There were 5 motorists and a VSL technician who was standing on the deck. There were 2 other motorists who were seriously injured, and another one of the technicians from VSL is now permanently disabled. That is the personal aftermath of what happened on this day. And unfortunately, there's not really a good way to transition to the professional aftermath. I think it certainly pales in comparison. But that is what we're here today to talk about and to learn about as members of the engineering community. And so in terms of the professional aftermath, there were a number of things that occurred. There were, of course, lawsuits from the victims. There were investigations from both OSHA and the National Transportation Safety Board. There is the possibility still outstanding of even criminal, but certainly PE board investigations. And then, of course, there's reputational harm to the firms that were involved in this. And we're going to talk about each of those things in turn here. The lawsuits actually, they happened pretty quickly, and they were resolved pretty quickly. There were 25 project participants, and so honestly, anyone who touched this project paid something to these victims' families, and they contributed to a total settlement pot of $103 million. I say everyone except for, and I'm going to talk about them separately, but except for Lewis Berger, who did the peer review work. They, at the outset, they were not part of this $103 million settlement. So everyone except for the peer review firm contributed towards this, and we believe it was policy limits. We don't know for sure. And I guess I should say, everything I know about this, I've learned from publicly available resources. I don't have any inside knowledge. Certainly, Terracon was not involved in this project, but we believe that likely everyone paid their policy limits to resolve these disputes. Additionally, another $9.5 million was paid to the university. Now, Lewis Berger, they, as I said, they did not contribute to that $103 million. And I think the reason for that is largely, this is just kind of me reading between the lines. But they're looking, saying, hey, look, we did the peer review. This wasn't our design. We had a very, very limited scope of work. But in addition to that, they're one of the largest companies that was involved in this project. And so my guess is they probably had significantly more insurance that was put at risk. If you have a plaintiff's lawyer who's saying, I want policy limits from everybody, policy limits from Lewis Berger are going to look very, very different from policy limits from the concrete sub. And so they held out. And now recently they have resolved, separately, they've resolved their disputes with 3 of the 6 families. They are still proceeding against the other 3, and there's kind of a handful of other injury complaints, kind of everything from someone who is very seriously injured to there's one claim that involves a guy who was riding a bike who said that when he was riding his bike, there was a car and the car saw the bridge collapse and he was distracted and he hit him on his bike. Therefore, he's going to sue the peer review firm. Again, apologize, that's me being a defense lawyer for a second, but so they're still holding on to some of these and are still going through the process of disputing some of those lawsuits. But I would say largely speaking, these have been resolved. What also happened though was you had investigations from OSHA and the National Transportation Safety Board. And they both reached the conclusion that this was a design error. Needless to say, FIG tried very hard to make this into a construction issue, and neither one of these agencies was convinced that was the case. They said that it was a design issue and that was the primary reason for the collapse. They also took specific issue with Lewis Berger's work. Now, as the peer review firm, and we're going to talk a little bit about this, they said that Lewis Berger did not do enough in their scope of work as the peer review firm, and if they would have done their work appropriately, they would have caught this issue. And we're going to talk about that. But then finally, they said that all the parties failed to act on the warning signs and to cease work. They said nobody shut this project down. No one closed the road. No one put any support in underneath this span. And so when the report from the NTSB came out, there was a statement that was issued by the chairman that accompanied it. And he says the bridge was talking to them. And it wasn't just talking, it was screaming that there was something definitely wrong with this bridge. yet no one was listening. Pretty strong words. And that certainly was the theme of the NTSB's report. They were critical of everyone for not stopping this work. And we're going to talk about that here in a second. But at the outset, they said, just from a pure design standpoint, the design underestimated the loads at that connection between that diagonal number 11, the vertical 12, and the deck. And they said at the same time, it overestimated capacity at 11 and 12 to resist shear because of the incorrect loads in the calculations. But then they also said there was a lack of redundancy in the design. And so again, going back to this idea of it's an unusual bridge, it's a unique bridge, it's a design that we've never seen anywhere in the world. One of the things that they were very critical of was the fact that this entire structure it rested on the strength of that single truss running down the middle. And they said, and you can see just by virtue of the fact that once member 11 gave out, there was no redundancy. There was nothing else to keep that bridge in place. But I would say more than the design issues, OSHA and NTSB really faulted the parties for their inaction. And they were very specific in calling out Bolton Perez, who is the CEI firm. And they said that Bolton Perez should have recommended to close that road. They should have recommended to FIU and to FDOT that essentially they should have gone around the structural engineer of record, who said multiple times this is not a safety issue. And they should have used their own independent professional judgment to say, we think there is an issue. We think there is a safety concern. Now, if I'm the lawyer for Bolton Perez, I'm saying they did everything they were hired to do. They went out, they photographed this, they provided the information to the owner, to their client, the owner, who could then make whatever decisions they needed to make. They, again, I would argue that it is the job of the structural engineer of record to make the calls that they were making. And TSB and OSHA have a different opinion, quite frankly, and they say that not only should Bolton Perez have gone to FIU and FDOT and recommended that they close the road, they say that they even had their own independent ability to close it if they wanted to, because they were working sort of on behalf of FDOT. I don't know that that's the case, quite frankly. But I also know that my opinion in the matter doesn't really matter, because the National Transportation Safety Board said that Bolton Perez should have gone out and closed the road on their own. Right. With regard to Louis Berger, the NTSB and OSHA were critical of their work as well. And Louis Berger was very quick to say, we had a very, very limited role in this project. We were hired to review the final design for the completed bridge. And NTSB and OSHA both said, well, your review should have looked at every single stage. So, we talked about the 8 stages of construction. You should have reviewed the conditions for each one of those stages. And Louis Berger said, we tried to do that. We tried to get an agreement with our client, with FIG, to do that. And the engineer who did this work testified, and this is a quote from him. He says, in the beginning, I suggested to do this kind of analysis, to analyze the connections. I'm talking about the nodes or the joints, to analyze the connections. However, the budget and time to do this actually was not agreed upon with the designer. So who hasn't been in that position, where you go to your client and you say, these are the things that I want to do. This is going to give you the best final product. And the client says, I don't have a budget for that. And so between FIG and Louis Berger, they decided that FIG was really only interested in having a peer review of the final, complete, in-place design. But to add insult to injury, they cut their fees for that work. And so Louis Berger said it's going to be $110,000 to do this review of the final in place design, and FIG said I only have 60,000. So FIG did it, or excuse me, Louis Berger did it, and they took the $50,000 pay cut. They did the limited review, and their contract's very clear in terms of the review that they were going to do, and it truly was just the final bridge design. But as NTSB and OSHA pointed out, this is an FDOT project, and FDOT has its own rules and regulations, and the FDOT regs require a comprehensive review with a different design program. And what between NTSB, OSHA, and FDOT, what they all concluded was that a comprehensive review is not a review of just the final in place design, but it's a review of every single stage of that construction. And so Louis Berger was cited by OSHA and by NTSB for violating those FDOT regs and not reviewing the stage and design. And again, that was not what they were hired to do. But NTSB and OSHA, they didn't care what they were hired to do. They said they had their own obligation to do this if they were going to be involved in an FDOT project. So in addition to agency action, there is still the potential, and I want to stress potential, but there is still the potential for criminal action. So this is a headline from the Miami Herald from about a year ago that says, "Feds figured out why FIU bridge fell. Now prosecutors must decide if deaths were a crime." This is something that is on a lot of people's radar, and they are absolutely looking at that. Now, I think as time goes by, I think the likelihood of that lessens. But I think something like this, where you've got the NTSB report, which is extremely critical of everybody involved, and you have 5 members of the public and 1 worker who lost their lives because of this. There's going to be that pressure to at least, if they're not going to pursue criminal charges, to be able to explain why. And I think one of the things that may impact that is something else that's still out there, which is the input from the Florida Board of Professional Engineers. And if you go to their website right now, excuse me, if you go to their website right now, there is a page talking about the FIU pedestrian bridge collapse. And it's been up for about 2 years now. And it says that the board is going to monitor developments as other agencies, and they're referring to OSHA and NTSB, as other agencies complete their investigation. And if the cause is determined to be an engineering issue, FBPE will take any necessary steps, including disciplinary actions, to ensure public health and safety. So they're setting their position out right now, and they're saying, we are waiting to hear back from NTSB and OSHA, and if it's an engineering issue, then we will take action. Well, all of that has occurred. NTSB and OSHA have completed their investigations. They've issued their reports. They had said unequivocally that it's a design issue. So my assumption, and it's only that, but my assumption is the Florida Board of Professional Engineers has now picked it up from there, and they're doing what they need to be doing behind the scenes to figure out what licensure issues there may be. But I fully suspect that this is going to be the next stage in that process. For all of the companies involved, there has been reputational harm, and I say that without judgment in terms of whether or not it's merited. It's just a fact of life. There's been reputational harm for everyone who has touched this project. MCM is bankrupt, and they've emerged from the bankruptcy, restructured, and they've rebranded themselves as Magnum Construction Management as opposed to Manila. They changed their name, I would say, in no small part to distance themselves from this project. FIG, BPA, Louis Berger, they've all had brand damage. I would say probably none more than FIG, which we're going to talk about here in a minute. but they've all suffered brand damage because if you search for any of these companies' names, one of the first things you're going to see is an article about the FIU bridge collapse. You just are. But then there's also the individual engineer who's had reputational damage, and that's Denny Pate. And so if you look at this screenshot, this is from ENR. I mean, this is from a trade journal, something that's very, very favorable to the industry, but they chose to use this picture of the design with his seal there front and center. And so Denny Pate has been a pretty visible part of this investigation and the aftermath throughout, and he has no doubt suffered reputational damage as a result. But there's still, even to this day, we're now 2.5 years past this. There's still continuing fallout. So just recently, in the past couple months, MCM has sued Louis Berger. And in the time since the bridge collapse, Louis Berger was acquired by a company, WSP. MCM has sued WSP, saying that basically the money that they had paid out to the families of the deceased, that really should come from Louis Berger, who did the peer review of this design. Interestingly enough, they don't name FIG in that lawsuit, which to me says that a separate deal has been cut, and I don't mean that nefariously. I just mean that they have resolved their issues, and now MCM is still looking to recover from anyone who's still around and has some money, and I think that's Louis Berger and now the company that owns them. Again, Louis Berger is still preparing for trial with some of these individuals, and with courts being shut down for COVID, who knows how long it's going to take before some of those issues get resolved. But I think that of the continuing fallout and the reputational harm, I think FIG has seen it the worst. FIG was recently hit with a 10-year debarment from the Federal Highways Administration. They lost 2 very large projects in Texas, very, very high-profile projects. One of which, if I recall correctly, I believe the CEO has said it was responsible for 42% of their revenue, just that one project. But this 10-year debarment from essentially all government work, and of course FIG specializes in bridges. There are not a lot of private bridges being constructed, quite frankly. The CEO for FIG has said that if this order stands, and they've tried to get it overturned, they haven't been successful as of yet. I think they're still continuing. But the CEO of FIG has said that if that order stands, then there will not be a FIG. That they will cease to do business. So that fallout continues. Now, generally speaking, when I give this presentation, I like to turn it into a conversation. It's kind of hard to do that through WebEx, but I'm gonna leave you with a couple of thoughts before we get into question and answers, because I would imagine there's probably going to be quite a few. The first is the CEI's role, and whether it is their obligation to question the structural engineer of record. NTSB and OSHA said, unequivocally that Bolton Perez failed to exercise their own independent professional judgment. I would argue that they did everything that they were required to do by contract. So they're out there, they're taking pictures, they're reporting that information back, they're keeping the decision makers informed of the current conditions on site. But the question is that enough? And I've had this discussion with a number of different groups of people, and it seems like there's a pretty even split between people who say their role is not to second guess the structural engineer of record. That is not their job. Their job is to again, is to keep the owner apprised, to document the conditions, to give everyone the information they need. There are others, though, who say, particularly in a situation like this, particularly when you have members of the public driving their cars under your active construction site, that they had an obligation to raise this, to raise the issue of closing down the road, to essentially publicly call out the structural engineer of record and say you're wrong. I think we would all probably agree that's not an easy thing to do. I also, though, wonder if you were to ask some of the people who were involved in this project, do you wish you would have done more? And if they were, being honest and there weren't lawsuits out there and everything else, I have to think that you would hear a yes. I just think that that's the case. But that's a hard dynamic, that interplay between the CEI firm and the structural engineer of record. And again, I think while the NTSB and OSHA have clearly staked out their position, and I think it's an important one to be familiar with, particularly if you're doing work as the CEI. I think it is an important one to be familiar with. But while they've staked out that position, I do question whether they would have taken as strong of a stance if 5 members of the public and one of the workers on site had not died. I mean, I think that this is such a tragic event that, to a certain extent, it drove some of these conclusions perhaps to a place where they wouldn't naturally go otherwise. The other thing that we talk about and that I want to kind of leave you with is this idea of the risk of doing a peer review. And peer review is something that as an industry should be embraced. The idea of having another engineer who could look over that work product, who can use a different system. The idea should be that the finished product is that much stronger. Unfortunately, that's not always, well, I should say the incentives are not always there to do that. And so if you look at Louis Berger, who made $60,000 on this project and undoubtedly paid, and again, I don't know the numbers, but millions of dollars, presumably, for these lawsuits, they have to be looking and saying, why are we doing peer review at all? If we're taking on the risk of the prime designer, which is essentially what they've done now, and they're getting the fees for a very, very small sub-consultant, what's the benefit of that? And I think part of that comes down to how we deal with lawsuits that relate to peer review firms. In the United States, there are only 2 states that provide immunity for engineering peer reviews, and that's Kansas, where I'm at, and right next door in Missouri. Those are the only 2 states that provide immunity for peer review work. Otherwise, if you're doing the peer review, you're very much in the mix with everyone else, and for a tiny fraction of the fee, and it becomes very, very difficult to manage that risk, which is why I think it's difficult to incentivize firms to do peer review work and for firms to have that peer review work done. I mean, you can see from this situation how FIG viewed the role of the peer reviewer. Very, very limited scope, and then cut their fee almost in half for doing it. It was almost, and again, this is just me talking, but it appeared to be more of a box checking exercise than a true independent view into this project, which is what I think you should want. The other thing that I think that you need to keep in mind is, are there external requirements on your scope? So going back to peer review, the NTSB and OSHA, they spent a lot of time talking about Louis Berger and their role as the peer review firm. What they never did, they never pointed out a single thing that was wrong about their peer review. They didn't. what they said was, you didn't look at enough things. So the final bridge design, when everything was in place, there was no criticism about Louis Berger's review, their peer review of that design. The criticism was simply that they didn't look at it stage by stage by stage, and they didn't. Again, and we know why. But it was only because of these external requirements, because FDOT has these external requirements to say, if we're funding this project, you have to have a comprehensive peer review. It raises the question, whose responsibility is it to know that? Is it FIG who is doing the prime design, who's working most closely with FDOT? Is it the role of the peer reviewer to look at that and say, I know you want to hire me for X, but I have to do X, Y, and Z. In this case, the NTSB and OSHA made no bones that they said both of them were required to know this. Both of them should have known this, and they were very critical of Louis Berger for going forward with the project without getting that full scope of work, which again they tried to get, and they were unsuccessful. But more than anything else, I think if there's anything that we can take away from this, it's the duty that is owed. The duty that is owed to the safety, the health, and the welfare of the public. I think this is the most troubling case study, certainly that I've had to talk about, because while people were meeting, while they were having these discussions, while they were trying to figure out what's going on with this bridge, when they're saying our engineering analysis can't replicate these cracks, all the while members of the public are driving underneath it. And no one, to my knowledge, no one stopped and said, we need to get those cars out from underneath there. We need to stop sending more cars through there. We need to shut this thing down until we know exactly what's going on. And unfortunately, that didn't happen. And unfortunately, 6 people lost their lives as a result. And I know this is an unusual thing, in that most of the construction sites we work on, there isn't that true, direct, tangible connection to the public. But I think that it's something that I would hope that everyone would take away from this is, please do not forget that duty that is owed. And again, I think that in this case, that's what unfortunately makes this this case study so, on the one hand, egregious and at the same time very, very tragic. So I appreciate the opportunity to be here and to share some thoughts with you, and I'll happily, to the best of my ability, answer any questions you may have.
Okay, great. So we've got quite a few. We'll get through as many as we can.
Okay.
Does FDOT define what a peer review includes? And if so, why is this not a separate contract?
So FDOT, if I recall correctly, they refer to this thing as a comprehensive review, and there is some information in terms of what that means. I think 2 things happen here. I think number one, it's not all that well defined what a comprehensive review is, and I think that after the fact, some of these agencies have latched onto that and said a comprehensive review must, in this case, include all the different staging, things like that. But I'll say the second thing that happened here is I don't think anybody involved in this project was aware of that reg. So I don't think there was a determination at one point in time that this is a comprehensive review or it's not a comprehensive review. I don't think that was on anyone's radar at the project level team. And FDOT's involved in this project. I mean, they're sitting right alongside the owner, and no one raised this. Again, to my knowledge, no one raised this during the project itself and said, well, wait a minute, we need a comprehensive review. All this came after the fact. And so, I'm sorry, what was the last part about a contract, a separate contract?
Right. Why would it not be a separate contract?
I guess I'm not entirely sure who that contract would be with, if that's through FDOT or what. I mean, my understanding is that the designer, it's incumbent upon the prime designer to have this comprehensive peer review. And so, between the prime designer and the peer review firm, that's the way I see the contract working. But again, I think, in this case, neither party to that contract really understood what was absolutely required. They just saw this more as, we can transact to figure out what the appropriate scope is for the appropriate fee.
All right, next question. Was this design build, design bid build, or construction manager at risk?
My understanding is it was design build. And so MCM they were the design builder, and they served as the general contractor. But my understanding is the entire project was design build.
Okay. Did any insurance companies pay out on any claims?
Yes. So again, that we have some information, but we don't have all the information. So we know $103 million was paid out in total to some of the victims' families. We don't know who exactly contributed what to that, but it's my understanding that largely everybody who I guess I would say was a kind of a major project participant paid out the full extent of their policies. They made a policy limit payment. And now for some companies, again, for the concrete sub, maybe they have $1 million in insurance. And my understanding is MCM, and again, this is all just kind of, some of this has come from the bankruptcy court. Some of it is just sort of people talk. But my understanding is MCM did not have a significant amount of insurance, considering the type of projects that they work on. I don't know that for a fact. But to the question, did insurance pay? Yeah, absolutely. Everybody's insurance paid. And again, I think that's also why Lewis Berger, in my mind, has been hesitant to settle, because they're looking, saying, if the concrete sub has $1 million in insurance, and and I, as Lewis Berger, have $45 million, and you make a policy limits demand to both of us, and I'm the peer review firm, I'm not going to pay $45 million to resolve something that I honestly don't think is my fault. Tragedy aside. So I think that is what has kept them from settling some of these other claims, is just the fact that I think they most likely have more insurance available to them than some of these other players, but they don't want to exhaust their policies and leave themselves uninsured, and deal with trying to get insurance for next year. I mean, it's not a one and done type deal.
We have a question about, did they rebuild the bridge with another company or design? What's the current status of the bridge?
The current status is there still is not a bridge. They are, I believe, I have to double check this. I believe they are still in the design stage for a replacement. I mean, they've essentially scrapped everything that had anything to do with the original project. I don't expect anyone who was originally involved is going to be involved in the next round, and it's going to most likely look substantially different. But as it currently stands, there is nothing there in place.
Were some of these same lessons part of the Hyatt pedestrian walk collapse? If so, why has the industry not adopted procedures to reduce risk?
That's a good question, and I would say I know enough about the Hyatt Skywalk collapse to be dangerous. And if I recall correctly, it actually had to do with a change in actually one of the physical components that was used to connect that skywalk, and I can't remember how exactly that change was made. I think that honestly the thing that connects the two is human nature. If you're sitting in a room and the structural engineer of record is saying this is not a safety issue, it's very, very difficult for someone who is not the structural engineer of record to stand up and say, you're wrong. To say, I know that you've been building bridges for decades, but I think you're wrong. And it's difficult to ask people to do that. And it does not come naturally to people. I mean, there's a very, very strong desire to avoid conflict. And I think that played a role probably in both of these, to the extent that there was a decision made like that with the Hyatt Skywalk collapse. But when you have people sitting around the table and you have the person who is supposed to be the expert, and they've shared their opinion, it's very difficult to say, I don't agree with that. And so I think that the lesson that needs to be learned from this is how do you lessen that conflict? How do you make it more comfortable for people to speak up? And so that could be as simple as saying, this is what I found. Does anyone have any reason to question that? Does anyone want to know more about how I reached that conclusion? Having heard that, does anyone still have concerns about this? I think that if you can invite that discussion and make it less of someone having to really just stand up and pound the table and say you're wrong, I think that is probably that's going to be the way that you can at least try to overcome some of that aversion to conflict. And having worked with a number of really, really excellent engineers, I know that aversion to conflict can be a very real thing. And when people are slotted into their roles, there is definitely a tendency to defer to that role and that authority. But I think if you can start by making it more of an overtly collaborative process, you can at least make it possible to have some of those conversations.
Okay, so there had to be an independent check of the analysis within FIG, not the peer review. Do you know if that happened?
I don't know for sure if that happened. That was not mentioned in the reports that I read, so I don't know for sure.
Was this the first time that ABC was implemented?
I've actually wondered that as well, and I haven't had a chance to really dig into that. I've wondered that as well. I think that, I don't know that the method itself is to blame, but certainly when you're talking about staging things like this, and I know that FIG. I know that FIG's design allowed for these different stages, and so the design was supposed that main span was supposed to be able to stay on that pier and that pylon while the rest of the work was completed. But I don't know for sure if ABC has been used elsewhere, and I'm curious too.
We actually got a comment from another attendee that says, no, it's actually used all over the country.
Oh, okay.
All right, we'll take one more question. Did the contracts have limits of liability indicated, and did they matter in this sort of an event?
That's a great question, because that's that's how I spend my days. So I don't know for sure if the contracts had limits of liability. Here's what I'll say though. So a limit of liability may come into play if, so for instance, I talked about how MCM is suing Louis Berger for that payout. Although they would not have had a direct contract, they would have gone through FIG. So let's say FIG had sued Louis Berger and said, hey, we had to pay out a whole bunch of money. Now you need to indemnify us. A limit of liability would come into play there. And so if they had $1 million LOL, then Louis Berger's liability would be limited to that $1 million that they would have to pay to FIG. In a situation like this, though, where you have using a legal term, strangers to the contract, members of the public, people who did not sign up for any risk whatsoever associated with this project, the limit of liability would not come into play. And so that's really why it becomes more a question of how much insurance do you have? And the reality is you don't have to stop at insurance either. I mean, you can you can recover whatever you can recover, but a limit of liability, at least as far as the claims from the 5 members of the public who were killed, their claims would not be limited by contract or anything else.
Okay. There are some questions that we did not get to. I will get these over to Aaron and see if we can get them answered offline.
Sure.
We appreciate your time today. Obviously a very important session here, and we appreciate you providing your perspective.
No, thank you very much for having me.
Sure. Attendees, your PDH and NCBEL survey will be emailed to you after this session today. We will resume our virtual Raleigh seminar tomorrow at 10 a.m. Thank you all so much. Have a great evening.